My Lord, I was showing you the draft amended pleading at tab 8 of the supplementary bundle. I think I just showed you paragraph 23b, sets out our case on the costs that would have to be incurred in order to obtain cabling access over the new easement. And then at paragraph 23c, we say that we'll rely on those matters as evidence of the diminution in value of the company caused by the defendant's breaches of the agreement, and so as evidence of the loss that we've suffered by reason of the breaches, assessed as at the time of our discovery of them. And the case works in this way. We say that when one's looking at the diminution in the value of shares in this kind of situation, one can measure that loss, measure that difference in different ways. So one way would be to assess the price at which the shares could have been sold in the market, warranty true and warranty false. But another valid way of getting to that diminution is to assess, as it were, the cost of cure. In other words, the cost, as at the date of breach, of putting the company, and therefore of putting the claimant, in the position in which it would have been in if the warranties had been true. And that, we say, is an alternative way of coming to the loss that we pleaded at paragraph 22 of the difference in the value of the shares, warranty true and warranty false. Now, for present purposes, the court does not need to decide whether that way of putting the case, in other words, measuring the loss by reference to cost of cure, would be a valid way of assessing loss in the present case, as opposed to, for example, as the Master of Rolls I think was indicating, looking at the market price of the shares with or without the warranties. It's fair to say there was some debate below about the correct way in which the case could be put. But the judge did not in the end reject the amendment on that ground. And subject to the question of notice, which I'll come to in a moment, he did not hold that there was anything demurrable or objectionable about the pleading as he proposed to put it forward. Although I think he did say that had he permitted the amendment, he would have required some further particularisation of paragraph 23c. So what we're concerned with on this appeal is the question of whether there was a real prospect of showing that the claim, as we seek to plead it, had been adequately pre-notified in accordance with the SPA. It's a notice assuring.
And there's no respondent's notice?
No. On the point of the adequacy of the claim as pleaded, there is not. So it is, I mean, the exercise ultimately, I suggest, is one of essentially, perhaps slightly simplifying it, but comparing what's in the pleading, which represents our pleaded case, with the notice. And in terms of the content of the notice, or the required contents of the notice, I'm sure you're familiar with the notice provision. It's in the main bundle at tab 60, where we have all the relevant contractual clauses. And you'll find it at page 193. And top of the page, seller shall not be liable for a claim unless the buyer has notified the seller of the claim, stating in reasonable detail the nature of the claim and the amount claimed, detailing the buyer's calculation of the loss thereby alleged to have been suffered. So there are, at least as the judge approaches, and I will too, that there are two limbs to it. There's the nature of the claim and the amount claimed with detailing the calculation. Now, there are a relatively small number of authorities which deal with the general approach to notification clauses of this kind. And the leading case, as I think both parties accept, is the Court of Appeal's decision in Dodica and United Luck Group holdings. And the relevant passages, I think, from that case, we can take probably directly from the judgment below. And your Lordship will find, first of all, if you go to paragraph 60 of the judgment below, page 122 of the bundle. Paragraph 60, the judge refers to my reliance on and Mr. Hussein's agreement with what Dodika says about what Justice Popplewell said in Dodika about the purpose of a notice clause. The purpose of a notice clause is to enable the recipient to make such inquiries as it is able and would wish to make into the factual circumstances giving rise to the claim, with a view to gathering or preserving evidence, to assess so far as possible the merits of the claim, to participate in the tax investigation, that being the nature of the claim in that case, to the extent desirable or possible, with a view to influencing the outcome, and to take into account the nature and scope of the claim in its future business dealings, whether by way of formal deserving or more general assessment of the potential liability. And then there is another passage from Dodika, which is the other one we relied on, over the page at paragraph 62, where the judge comments that in Dodika it had been accepted that the additional information the vendor contended ought to be contained in the notification letter would not have advanced any of the commercial purposes of the clause. And again, Lord Justice Popplewell said, I balk at a conclusion that the level of detail provided in a notice of this sort fell short of what was required as reasonable, that is to say, was unreasonably deficient, when the additional level of detail said to have been required would not have furthered any of the commercial purposes for giving such a notice. What's reasonable takes its colour from the commercial purpose of the clause, and what businessmen in the position of the parties would treat as reasonable. Businessmen would not expect or require further detail which served no commercial purpose. That would be the antithesis of what was reasonable. And the same point was put in a pithy way, but in my submission a helpful way, by His Honour Judge Waxman, as he then was in High Water Estates and Greybill. And again, I think the relevant passage is quoted in the judgment at paragraph 69, where the learned judge quotes His Honour Judge Waxman saying, the commercial purpose of such clauses is to enable the vendor to know in sufficient detail what he is up against, not least because it might then enable the party to settle without recourse to litigation. So what those cases show, and particularly the Dodika in my submission, is that when one is considering what information needs to be notified in a clause of this kind, it's critical to consider what the reasonable recipient would reasonably be expected to do with the information when he was given.
So was it said how it would have helped them if you'd given further detail?
In this case?
In this case?
Yes. Well, so ground 3 of the appeal concerns that point, in the sense that the judge himself, in attempting to deal with that, set out why he thought, wrongly in our submission, it would have served a commercial purpose. And I'll come to that in due course, but that's really paragraphs 98, 99 and 100 of the judgment, where he sets out why he thinks it would have served a commercial purpose, and I'll come in. I'll address it now. I was going to come to it when I get to ground.
I mean, one feature of this case is that if the amount of the claim is comfortably below 7,200,000 or whatever the figure is,
yes,
then one thing that the recipient can safely do is ignore it.
Yes, and for that reason, it's important, obviously, that the notice states the amount of the claim, because you're absolutely right. If the amount stated is less than the threshold, then the defendant can safely ignore it. If
I
it's
mean, unless there are other claims potentially in play,
right,
but we're not aware of any.
No. And that, of course, would be a commercial reason why there should be a number stated for the amount, and perhaps even a breakdown of the number between different claims.
Mr. Guest, could I, the bit that strikes me about these ways of expressing the commercial purpose,
yes,
which puzzles me is they don't say anything about part of the purpose, as I understand it, of these clauses, which is to act as a limitation, as a sort of private form of limitation. Because if you don't give notice within a certain time, you can't bring the claim. How does that purpose of these clauses play out?
That obviously goes to the question of the timing of when a notice is made. In my submission, it doesn't really help in identifying what the content of the notice should be. Okay.
It just strikes me as being surprising that since one of the things that these notices are for is if you don't give notice within a certain period of time, you can't bring a claim at all.
Right.
That, I mean, forgive me for being naive, but that would strike me as being something that's relevant to the purpose of the clause, which is, it doesn't seem to figure in these expressions of what the purpose of the clause is. That's my point.
I see that. I mean, it may be, I see your Lordship's point, it may be that in a sense that goes without saying in all of these cases, because they are all cases necessarily where, and of course the whole reason the point was before the court, is because one party was saying that because there was an inadequate notice, the claim was barred. So we're not concerned with claims where people are saying that there's a claim for damages, let's say, because of the inadequacy of the notice. But they're all necessarily claims of that kind. And of course that does factor in this way, that they are all exclusionary clauses, and therefore to that extent one needs to be a little bit cautious in how one reads them. And in my submission, the point that's being made in the sort of Tadika cases and the similar cases, that if you are going to exclude someone on the basis that you haven't provided sufficient information about the claim, it is fair and commercial to ask the question, well, what purpose would that additional information have served? And that, in my submission, is where I think the Court of Appeal in Tadika is coming from, and also he's on a Judge Waxman. There are also some authorities which cast a little bit of light on some of the particular expressions used in the present case, in particular the expression nature of the claim and the expression in reasonable detail. Just before showing you those, I would just observe that the expression in particular, the nature of the claim, is linguistically a rather imprecise or general expression and not easy to apply in the abstract. What I suggest one can say, though, is that the nature of the claim is something broader and less specific than, for example, particulars of claim or details of claim. And nature of the claim rather more conveys the idea of the basic or fundamental features of the claim rather than the details or reasoning on it. In terms of the authorities, first of all, and again, I think we can just conveniently take this one from the judgment. Paragraph 65 of the judgment below, the learned judge referred to the Laminates case and the judgment of Mr. Justice Cook. You see at paragraph 65, he had said that the parties had agreed, in fact, that the nature of the claim means notification of what is being claimed and the basis of it by reference to the SPA, namely the form and substance of the claim. And I should perhaps just add to that the problem in the Laminates case, and the reference, if you notice paragraphs 37 and 38 of Laminates, is that the notice hadn't even identified which warranty was alleged to have been breached. And that was said not to be a valid notification of the nature of the claim. And then we have the ROK PLC and Harrison. And could I ask you please to take that one from the authorities bundle, just because there are a couple of other passages I wanted to show you. It's a decision of Mr. Richard Sybry, Queen's Counsel, sitting as a deputy. And if you have it, if I can ask you first to go to paragraph 13, you'll see the clause in question. You see that clause 5. Vendor not liable for a claim unless notice in writing, and then the wording specifying in reasonable detail the nature of the claim and the amount claimed, based in each case on the information then available to the purchaser. So it's not identical to our clause, but it's similar in the sense that it refers to the nature of the claim and the amount claimed. And in terms of nature of the claim, if I can ask your Lordships please to turn forward to paragraph 61 of the judgment, under the heading Discussions and Conclusions. The judge says the notice clause is, as ROK submitted, a relatively low threshold notice clause in comparison with some. It requires written notice of the claim, which specifies in reasonable detail the nature of the claim and the amount claimed, but it does not require details or particulars to be given of the grounds on which the claim is based, or of the matter, or events and circumstances which have given rise to the claim, or of the specific matters in respect to the claim is made. The parties have not provided for that degree of specificity. They've chosen as an expression the nature of the claim, which is more general and less prescriptive, as was recognised by Mr. Justice Dyson in Odebrecht, in contrasting the phrase nature of such breach with the detail of the breach. The judge also makes the point in the last 10 lines or so of the next paragraph, paragraph 62. If you have it, it's about 8 lines up, middle of the sentence it begins, it would, however, not be correct. He says it would, however, not be correct to approach the construction of the notice clause with any preconception that, for example, the parties must have intended that the notice would enable SHG immediately to identify and embark on a detailed investigation of each package in respect of which figures in the June CVRs allegedly made insufficient allowance. SHG would have received the letter in the knowledge that if any claim thereby notified was to be pursued, proceedings in respect to such claim would have to be issued and served within 6 months, that being a requirement in the contract, and that detailed particulars of any such claims would have to be given in those proceedings. And there is a similar provision in the sense of that it's a 6-month time period for the issue of proceedings in this contract too. And then in paragraph 63, the judge goes on to say, in my judgment, the stipulation, the nature of the claim be specified in reasonable detail, requires as a minimum that the notice should identify the contractual provision under which the claim is said to arise. It would not, in my judgment, have been sufficient for a notice to state simply notifies users a claim for breach of warranty estimated at X. So obviously he puts that in terms of at a minimum, I accept that, but nonetheless it gives a flavour of what the judge in that case understood to be meant by the nature of the claim. And then finally on this case, we have paragraph 67, which refers to the expression in reasonable detail, which again also appears in our clause. And the judge says there that the words in reasonable detail were presumably intended to add something to a requirement to specify the nature of the claim and the amount claimed. It's impossible to define in abstract terms what would or would not constitute reasonable detail, although it's clear, as ROK submitted, that these words did not require ROK to give as much detail as possible in the light of available information. What constitutes reasonable detail will depend on the nature of the claim, bearing in mind also it's unlikely to be in the party's intention at the time of contracting that the details to be provided should be as extensive as those that would be required, doubtless after further investigation in the legal proceedings to be issued and served.
I mean, it's hard to think that authority can really help with the interpretation of perfectly normal English words. I mean, we're not going to be hidebound by passages like this that are obviously sensible in the context of their cases. Hopefully, courts will behave obviously sensibly in the deciding their cases. I mean, to go through 500 authorities about the meaning of perfectly ordinary words is, to my mind, probably a waste of everybody's time.
Well, you'll be pleased to know that was the only authority, or the only authority on this I was going to take.
In reasonable detail probably means in reasonable detail. Right.
But I think the one point, and maybe this is as much a linguistic point really as it is an authority point. One point I suggest you can take from the expression nature of the claim is that it is something less than particulars of the claim or details of the claim.
Yes.
just as a matter of plain English.
Nature, yes.
And
Nature
if you ask a commercial businessman, recipient of the notice, what do you understand by the nature of the claim? You're conveying something different than what do you understand the particulars or details of the claim to be. And I mean, as you noticed, I mean, in the end, one has to. That's as much guidance as one gets from the authorities, I suggest, and one really then has to test it by reference to the particular notice in this case.
And is the nature of the claim in this case anything more than that you didn't get a valid option because they'd given the deed of covenant to the wrong party, and that therefore put them, you say, in breach of various provisions of the contract? I mean,
exactly so. Exactly so.
Your case would be it's as simple as that, presumably.
I think we would accept. We would have to say that it's a breach of warranty, and we'd have to say which warranty it was a breach of. Because if we didn't say that, then the recipient would be scratching their head about what it was we're complaining about. But the nature of the claim is it's a claim by us under the SPA for breach of warranty X because you didn't give us the benefit of the option, or you didn't give the company the benefit of the option, and we claim damages. And because in addition, we'll have to come to that separately, there's a requirement for us to state the amount. But the nature of the claim is
well, the amount's a separate matter, but nature.
The nature of the claim is that. Now, and if I can then just, with that in mind, take your lordships to the notice itself. And obviously, in looking at it, you will have in mind, just sort of following on from what we've just been discussing, that one of the judge's fundamental objections to the notice was that it did not say, in terms, that the claim was one for the diminution in the value of the claimant's shares in the company. And he said that was a necessary part of stating the nature of the claim. He also said it was a necessary part of stating the amount, but he said it was a necessary part of stating the nature of the claim that it should say this is a claim for diminution in the value of the shares. Now, and before I look into more detail about why he came to that conclusion, there are just a number of points I need to make on the notice itself. If it's in supplementary bundle tab 5, if you have it in front of you, just a couple of points to make on it. First of all, it's a very long notice. It's 9 pages long. It's drafted by experienced solicitors, and if you look through it, it's this is a factual matter. It's very detailed and informative. Now, of course, the fact that a lot of legal time and ink was expended in drafting the notice doesn't in itself mean it's a good notice, so I accept that. That said, one must be cautious, I suggest, again bearing in mind the Dika approach, not to allow these notice disputes to become a kind of legal game where one pits the sort of drafting skills of one party against the ingenuity of the other to try and find omissions in it. The exercise should be about, if I can borrow His Honour Judge Waxman's expression, informing the recipient what he's up against as regards the nature of the claim. So if we look at page 1 of the notice, it clearly is a notice of claim. It's headed notice of claim. And it is, unfortunately the paragraphs are not numbered, but you will see that there's a paragraph that begins, this letter constitutes formal notice of. And it's specifically formal notice of a Damhead Creek 2 option agreement claim pursuant to paragraph 2.1.10 of Schedule 4 of the SPA. So it is a Damhead Creek 2 option agreement claim is defined as including a claim arising out of a failure to validly assign the benefit of the option. So it is explicitly a claim relating to the problem with the option. And then at the paragraph underneath, the notice says, in particular, this letter sets out in reasonable detail the nature of the claims and an estimate of the losses alleged to have been suffered. And I stress that because it's apparent, I suggest, from that paragraph that the context of this notice is existing losses that have been suffered by the claimant as a result of the breach of the SPA. And the notice, I suggest, doesn't really make any sense in any other context. And that's important because one of the criticisms that the judge made of the notice, which we'll pick up a little bit later on, is that the losses described in it were all described as effectively future or contingent losses. So the notice then sets out over the next few pages in considerable detail that we don't need to go through, all of the relevant clauses of the SPA which are relevant and which are alleged to have been breached. And then from paragraph 19 onwards, it explains the position in relation to the option and the failed attempt to exercise the option. From paragraph 26 onwards, it alleges as a breach of contract and refers to prior correspondence. I should just mention paragraphs 35 to 37 because the judge put some considerable weight on these paragraphs. They refer, as the Master of Rolls indicated, that some years after the original SPA, the company was sold on by Drax to VPI. And that's referred to in paragraph 35 as having taken place on the 15th of December 2020. And then at 37 it says Drax remains liable for any and all losses suffered by DGEL, that's the company, in relation to the reorganisation and the fact that the reorganisation was not implemented, etc. And the judge said, and this is paragraph 82.2 of his judgment, that the natural reading of those provisions in the notice was that the claim being advanced was based, he said, on Drax having incurred a liability under some form of unspecified indemnity that it must have given to VPI as part of the sale. And with respect to the judge, that is not in my submission a fair or tenable reading of the notice as a whole. First, there is no reference in the notice to any such indemnity, and there is no evidence before the court as to whether or not there was any indemnity. And second, had there been such an indemnity, it would presumably have been entered into on or about December 2020 when the company was sold. And it's hard to see in my submission how such an indemnity agreement could ever be directly relevant to Scottish Power's, the defendant's liability, for damages for breach of a different SPA, which had occurred 2 years earlier on completion.
But what if it could be shown that you'd sold it for exactly the same amount of money that you would have sold it for with or without this option?
Well, we would still, and this is our case, it would still be our case that the losses are to be assessed when you buy something, as at the date when you buy them. And if I buy something for X pounds, and based on the warranties, it should have been worth X plus 5.
Well, is it not, I mean, I understand that argument, but is it not an answer to that argument? Let's say you bought it for one day, it was notionally worth £10 million less that day, but the next day you sold it for exactly the same that you bought it for. Let's assume there's evidence that it meant that there was no difference in the sale price because of the problem. Is that not a defence on which the defendant can rely as to your assessment of damage?
It might or might not be. So 2 points on that. First of all, just dealing with that point specifically, I think we would say that the correct way to calculate loss in a contract case is the conventional one, that you assess the loss
As the date of breach.
If subsequently the market, if for example the market moves in your favour or things move in your favour subsequently, then the defendant doesn't normally get the benefit of that. Just as in the same way, he doesn't normally bear the cost if you choose to hold on to it and the market moves against
What's the principle, Mr. Quest, that applies here? I mean, I sort of get the it seems unfair that you should get your £10 million in damages in the circumstances that I speculated. What's the principle as to when subsequent events are relevant to the assessment of damages which you can crystallise as at the date of breach?
Well,
there must be loads of cases.
There are loads of cases because, as you know, the question of when the date at which one assesses the breach is controversial and depends on the circumstances. The other principle that might be in play, in theory, is the question of mitigation. It was said that you mitigated the loss in some way. But may I respectfully make this point, that in a sense, those points are all points that may in due course be raised by the defendant as a defence.
I'm sorry to interrupt, but mitigation is not really the situation we're talking about here, because nobody is suggesting you sold a £700 million asset because of this,
No.
and nobody probably could. So what you did was for other commercial reasons. So I'm searching for the authorities that tell you when you, in the ordinary course, do something for other commercial reasons, but nonetheless it can be shown that you didn't suffer the loss that was nascent at the date of the breach, whether you recover.
Well, I think I would.
Nothing to do with mitigation.
I see that. I think my position would be that we did suffer the loss at the date of the breach. The fact that by some separate transaction 2 years later, we may have been able to make a profit in a different way, which to that extent, I won't say made us whole, but it compensated in some way for the earlier losses.
Must be authorities on this. But you say it's nothing to do with us at all, because the judge did not decide your pleading was not competent. He wasn't trying the case, and we have to accept at face value that it's simply a question of notification.
Well,
that's interesting it may be, but it's not relevant.
Yes, and it no doubt will be an interesting debate, as it is in a lot of these contractual assessment of damages cases, as to what extent you can look at subsequent events as going to the question of assessment of loss. But it is right to say that. I mean, that's not the question on this appeal. That's not the reason the amendment was refused. The reason the amendment was refused is because the claim we had pleaded, which is a cost of cure case, the judge said was not properly the subject of the notice.
But can you just tell me the paragraph in which the judge gets unhappy about paragraph 37 and says there's an indemnity? I can't remember.
It's 82, paragraph 82.2, page 127 of the bundle. You have that, the Drax remain. That was a statement of how Drax.
So which paragraph?
82 sub 2.
Thank you.
Bottom of page 127. That's you'll see the reference to what he did was a natural reading. Which I think that's why I put it. So I mean the reason I've highlighted this this clause in this paragraph.
Have you appealed that finding, that natural reading point?
Sorry?
Have you appealed that? No.
Well, not as it were specifically, but that then reasoning is then deployed by the judge later on when he comes to say that the nature of the claim has not been notified, because he says the nature of the claim that's being notified in the letter is not the claim that we've pleaded, he said, but this indemnity claim. So it's relevant because it then becomes the underpinning, as we'll see in a moment, of the judge's reasoning as to why the notice doesn't adequately specify the nature of the claim, because he says it's notifying a different claim.
Well, what do you say is the liability which the recipient of this letter should have understood paragraph 37 to be referring to?
Well, I do say it's not the most perfect drafting, but what I suggest it means is, or what it's conveying here is, and particularly because it uses the word remains. And what I suggest it's saying is that it's conveying Drax's position that the claims that it has and that it sets out in this letter under the 2018 SPA for breach of the 2018 SPA are unaffected by the subsequent sale by the claimant of the company to VPI.
But that's not what it says. It says it remains liable for all and any losses suffered by DGEL in relation to the reorganisation. Yeah. Surely the judge was right to say that that implies that when and if DGEL suffers a loss, you're going to be liable for it.
Well, except that it's not, that doesn't make sense also with the use of the word remains liable, because Drax would never have been liable directly for losses suffered by DGEL.
Okay. So it's not good drafting then. Not helpful drafting.
But I mean, one has to. The problem, if I may say, with the judge's approach is he sort of picked out that paragraph and said, well, that then tells you what the whole notice is about, and therefore he said, well, that tells you the notice is really about an indemnity, claim under an indemnity. But when one sees that in the context of the notice as a whole, it clearly isn't. It's not sufficient in my submission to find, as the judge seems to have done, that the whole notice should be seen as framed only in relation to the liability under an indemnity, which is not even mentioned in the notice.
What's the position if the sender of the notice gives too much detail? That is to say, they identify accurately the nature of the claim, but they then go on to describe it in ways which pin it down rather narrowly, in ways which they later might want to escape from.
Well, I think that would have to depend on how it was put. I mean, clearly, if the effect of the of additional information was to make it clear that the claim was limited in some way, then I can see that the giver of the notice may then have the difficulty that if he said that his claim is limited in some way, he can't then say later that he has a different claim. On the other hand, if it was just redundant or excessive detail, that wouldn't, in my submission, detract from the requirement to notify the nature of the claim. And then just to complete the notice, we then have the section, perhaps the most important section under the heading loss. And in paragraphs 40, 41, 42, 43, we have essentially the same headings and the same numbers for loss, as I've shown you are now pleaded in the amended particulars of claim in paragraphs 23A and 23B.
I'm sorry to go on about this indemnity, but
Yes.
in 40, it does say, in the circumstances, the loss suffered is yet to crystallise.
Yeah.
So it is telling you, surely, carrying on from 37, that we're still liable for these losses which haven't yet crystallised, and therefore is the judge not right to say that what the information that is being passed across is that we, Drax, are on the hook when these losses that we're now going to tell you what they are, namely these costs, come in. And why do you shake your head there?
The overall context, I suggest, of this letter is the paragraph that I showed you right at the very beginning, which sets out losses that have been suffered.
Have been suffered.
Have been suffered.
But then it's inconsistent. What happens when you get a notice which is not clear what it means?
Well, one has to, with any document, try and interpret it. And the way I suggest that the natural way of interpreting it, if one tries to understand what's meant by the reference to the loss suffered is yet to crystallise, and to read that together with the earlier statement that the losses have been suffered, the reference to crystallisation, I suggest, means that the likely losses, or the losses that have been suffered, have not yet been ascertained, or have not been quantified. And so where the notice refers, as it does in paragraph 40, to crystallisation, both at the beginning and end of that paragraph, and in paragraph 41. Given that
really
it's
say that? I mean, do you really say crystallise means not quantified or ascertained? Crystallised normally means incurred, in the sense that I've got a car which has only got one wheel, and the loss has not crystallised because I haven't taken it to the garage and paid the £100 that will be necessary to repair it. I mean, do you say it means ascertained or quantified?
Yes, I say in the context of this notice, in particular the notice that's presented from the outset.
In context.
Yeah. I mean, in other circumstances it might mean something different. But this is a notice which starts by saying we have suffered a loss, and goes on to specify the facts and the warranties that give rise to the breach and the loss. And I think if you read all of this together, the fact that the notice uses the word crystallise does not detract and wouldn't be understood by someone reading the notice, I suggest, as detracting from the fact that the claimant, as the purchaser of a company, which has been sold in breach of warranty, or sold with warranties that have been breached, suffers a loss when it acquires it as a result of having acquired something less good than it was warranted.
I'm sorry to go on about this, but every word in paragraph 40 does seem to support the judge on his indemnity point. And you say that this is very critical. So I'm assuming that you're referring to paragraph 82 of his judgment, which we're going to come to later. Mm-hmm. And looking at this, it says, the loss suffered is yet to crystallize. As such, we set out details of likely heads of loss in relation to both the potential terms that may be agreed with Uniper in the event that such agreement is not reached and a compulsory acquisition is required, all looking to the future, all looking to the later crystallization. And given the unique circumstance, this is an estimate, i.e. of the future, and they're reserved with the right to update the loss suffered as matters develop and the loss is crystallized. So surely it is saying somehow we're going to be on the hook for these costs when they arise, but they haven't arisen yet.
In my submission, what it's saying, what the notice is saying, is we bought shares off you, which came with the benefit of warranties and promises. Those warranties and promises were false, and we have therefore suffered a loss in consequence of that. Because we're measuring our loss as the sort of cost of putting it right, we cannot yet precisely ascertain or quantify what that loss.
But why is the implication when you say because we haven't incurred these losses yet, because they haven't crystallized, because we haven't got the figures yet precisely for what is going to happen, does that not clearly infer that you're going to be on the hook for the amount of money that does crystallize? No?
In my submission, not. And to be clear, I'm not saying that the notice says that we have incurred the loss. Or, sorry, that we have not incurred the loss. Our position is that the notice is a notice of loss which has been incurred and was incurred in the conventional way on the date of the breach, and therefore on the date of the completion.
Okay.
The loss was suffered at that point, and the references in paragraph 40 that might otherwise, I think your Lordship is suggesting, are forward-looking, are only forward-looking in the sense that the losses have not yet been ascertained or quantified, not that they haven't been incurred. And in my submission, that's not a completely alien concept. I mean, there may be lots of situations where you buy something, warranties are breached, your cause of action has accrued, your losses are incurred, but you don't know what that loss is because it may require some considerable investigation in order to quantify it. And that, in my submission, is what this notice.
I really will shut up when I've said this, but isn't it support for a slightly better point that you say we've incurred the loss, and it's absolutely obvious that the loss we've incurred since we've sold the company is the depreciation in value of that company, and that's therefore, because we say we've already incurred the loss, and because we say we don't know how much it is yet, it may be about an indemnity, but it's definitely about the loss in value of the company.
Right, and the loss in value of the company, we say, to the extent you need to come to work out what that value is, I mean, you could do it by looking at the market price of the share.
Subject to defences.
Subject to defences, but you could also do it by looking at the cost of cure as at the relevant assessment date, and that's what the notice is conveying. And I mean, I do accept that there may be interesting and difficult questions down the line to argue about whether the way in which the claim is put is a correct way of putting it. But as I say, that's the question is whether the notice was adequate.
So does it come to this, that the legally skilled reader of this letter would scratch their head and say there's something missing here? It's either an indemnity or it's a diminution in value.
Yeah.
There's something, neither of those words appear.
That's true.
Is there any other mechanism that would explain, in the way what you're trying to do, as I understand it, is take the letter, read it, as it were, properly, and say, well, how can this work? And it could be an indemnity, that's the judge's view, and you say you're mistaken, I understand that. Another possibility is diminution in value of what you bought. I get that. Is there any other option?
Any other option of reading the...
To make this make sense, what you're doing is adding, there's
Yeah.
You see what I mean?
No, I didn't even necessarily
just say there isn't. That's fine.
I mean, what we say is that the reasonable reader of the letter would not need it, the legal analysis, to be spelled out. The reasonable reader, presumably with reasonable legal advice, would understand that the conventional way in which claims for contract breach of warranties are brought is one looks at what was promised compared to what was received. And measuring that, of course, in a particular case may be difficult, but the concept of a claimant in a breach of contract case comparing the value of what he got with the value of what he's promised, we would say is absolutely standard.
The judge's thinking seems to be that you are stuck with the way you put your case in the notice. That is to say, if you advance a claim based on some kind of indemnity, then that is the only claim which you can thereafter bring in proceedings. But I wonder whether that is right. The clause simply says that what you have to do is state in reasonable detail the nature of the claim and the amount claimed, and detail the buyer's calculation of the loss. Well, no doubt that's all got to be done in good faith and so forth, but it could be said that you did give a calculation of the loss, which is the way you were thinking about the case at the time, but you've since had second thoughts and chosen to put it in a slightly different way, but it's still basically the same claim. Are you shut out from reformulating your case once you get to the stage of proceedings, simply because of the way you've pinned your colours to a mast in the notice?
Well, one would only be shut out, in my submission, if the notice required you to specify your claim, as it were, in that level of detail. In other words, in the sort of detail one might have in a pleading. And of course, if you've got a notice which says you must explain the complete legal basis of your claim, and you did, well, then you'd be stuck with that. But as your lordship says, that's not what the notice requirement is. The only hurdle we have to get over in order to bring the claim is to show that we gave reasonable details of the nature of the claim and the amount.
But I mean,
and we did.
I mean, I'm only thinking aloud. But if what I suggested to you is right, then it may be that one doesn't need to spend too much time on working out precisely how the notice puts the loss, because it doesn't foreclose you from having second and better thoughts.
Well, I think respectfully that's right, because I spent some time in it because that's the way the judge approached it, which, as it were, it was sort of construe the notice in that way. But the ultimate question comes back to, is the nature of the claim stated? And if the nature of the claim is stated, then thereafter, yes, you're free to pursue a claim of that nature for, on whatever grounds that are properly pursuable. Which takes you back to the question of what the nature of the claim is in this case. I mean, perhaps I can, looking at the time, if I can just move on to what the judge actually said about this in the end, because he, having gone through these materials, the core of his reasoning, I suggest, is in paragraph 88, first of all. So 88 to 91, and this corresponds with our first ground of appeal. he deals with the nature of the claim point. And what he says in paragraph 88 is, first, it is part of the nature of the claim of answering the amended particulars. That it is a claim for diminution in the value of the shares in the company. And he makes essentially the same point in paragraphs 86 and 87. He says the nature of the claim includes a statement that it's a claim for diminution in the value of the shares. But with respect to the judge, one's bound to ask the question, well, why? The judgment is really, in my submission, just assuming the conclusion. That interpretation of nature of the claim does not follow from any of the authorities that we looked at. And one could equally, and in my submission much more naturally say, well, the nature of the claim is that it's a claim for breach of contract. We did say below, that more specifically, that the nature of the claim is sufficiently described by saying it's a claim for the breach of certain specific warranties in the SPA arising out of the failure of the company to receive the benefit of the Damhead Creek option. And if you asked any commercial bystander what the nature of the claim is, that is surely what they would say. They would not say, oh, well, it's a claim for diminution in the value of the share. It's a sort of legal analysis. And as I say, we made that argument below, and the judge recorded it really in the first first lines of paragraph 89, where he records us saying exactly that. But he rejects it because he says, and this is the fifth line of paragraph 89, he says, the nature of a claim goes further than that and includes where damages are claimed, how loss it is alleged to have been suffered. And then he explains how it would be put it in terms of an indemnity. And then about 6 lines up from the bottom of that paragraph, he says, similarly, where a claimant is saying that it has suffered reflective loss in the sense of a loss in the value of its shareholding in a subsidiary company through the defendant's actions affecting the subsidiary, that is part of the nature of the claim. It's part of the nature of a claim how the breach of warranty or other breach of contract is said to have caused loss to the claimant. But I mean, rhetorically, we would ask, well, why is that part of the description of the nature of the claim? I mean, that seems to be, in my submission, moving on from just looking at the essential features of the claim and starting to examine the legal arguments or the kind of jurisprudential basis on which the court can award damages to one party in respect of costs incurred by a subsidiary. Now, of course, there are questions about, in that example, about reflective loss and who's the correct claimant, and why, whether particular losses are legally recoverable, all of which would need to be pleaded out and argued in due course. But they are matters for the particulars of claim, I would suggest, and for subsequent legal argument, they are not.
What about causation? He says in the next sentence, causation is part of the nature of the claim, is it?
Well, then the link, it could be in terms of the link between there being a loss and the breach, but that I would suggest is
that is causation.
Is more than adequately set out in the notice. What one isn't required to do as part of the nature of the claim is to identify the rules of contract, which is what we've been talking about, as to how one justifies, from a legal perspective, an award of these costs in relation to the option that we set out as being the legal consequence of the breach of warranty.
Just to be clear, Mr. Quest, is the answer to my question yes, that you do accept that causation has to be explained as part of the nature of the claim? Because, well...
I would not accept that. I would not accept that it is necessary in every case for causation to be explained. For example, and obviously our notice goes much further than this, but in principle one could say that it would be adequately describing the nature of the claim to say there was a breach of this contract caused by the unavailability of the option and we claim damages as a result. something as
Because
short.
that's what the indemnity point comes to, isn't it? The judge is saying the causation is explained in the notice as being that you have entered into some kind of unspecified indemnity, which means you're going to be liable for all these losses. That's how your loss is caused.
That seems to be how he saw the notice as being put. Yeah.
That's what he says.
Yeah.
You said. And he says, I think he says, well, that's not really the nature of your claim. The nature of your claim is now something quite different, which is a reflective loss claim.
But my submission would be that matters of that kind fall outside the scope of what's necessary to provide one with a nature of claim.
What would be the situation if the letter of notice didn't make sense? In other words, you read the letter and it doesn't make sense, but you could make it make sense by reading in words like indemnity or reading in words like diminution in value. Would that mean that you'd given notice sufficient?
Yes. It's an interpretive exercise, ultimately. One must ultimately ask the question, what did it mean to the reasonable reader in context? Like any document, that might sometimes require reading in words or resolving ambiguities in some way. And like all documents, the court wouldn't, I imagine, likely sort of throw up his hands and say, well, this has no meaning at all. I mean, I suppose if there was some letter that was just simply completely incoherent, then one could say, well, it doesn't convey anything. But if there are ambiguities, they should be resolved, in my submission, to give the document effect rather than to not give it effect, since it was clearly intended to have effect. So we were looking at paragraph 89, which I say goes too far without justification in saying what the nature of the claim needs to include. The judge made the point at 91, again recording our argument, which I've also made today, which is to say that to the extent that there were the particulars of claim went further than the notice of claim, that was simply because we'd been more explicit in explaining how the measure of loss had been calculated. And he dealt with that about 3, 6, 7 lines down, where it says, however, whatever may be the legal merits of such an argument if it were run at trial, the problem here with the notice of claim is more fundamental than it having simply identified a different measure of loss. It was not just the method of calculating loss that was set out, it was the way in which Drax was alleged to suffer loss. The notice of claim identified the company's loss and said that Drax remained liable for the losses. It did not say that the Drax had suffered a loss by way of diminution. So that underlines the point I made earlier, that really at the root of the judge's reasoning here was the absence of a kind of legal explanation about how it is we said these losses were recoverable. And our fundamental point is that within the notice required, it just wasn't necessary for the notice to go so far. We also say, of course, that he was wrong in reading the notice in that way. And then just for completeness, at 92, he said, the point I just made, he said at 92, Drax also suggested that what was missing from the notice of the claim was simply a description of the legal basis on which it contends that damages should be measured. That seems to me to understate what's missing. It was not just a question of the identification of the correct legal label, but rather an explanation of a critical part of the claim now brought, namely how it was said the loss was caused, was missing. Indeed, a different explanation was included in it. Well, again, I mean, that's the same point that we've gone through a number of times now. That the error I suggest there is for the judge to read the requirement for nature of the claim as including what's essentially a legal analysis about how the losses set out are said to be recoverable as a matter of law. So these are, and of course the legal analysis it will have to be explained at some point, it will be part of the pleadings and so on. But ultimately these are points which are not part of the description of the nature of the claim, Rather, they're points that go to the question of whether the claim's a good one or not, or whether there's a defence to it. The judge then, so that was nature of the claim. The judge then, and the reasoning is quite similar, dealt with the question of the amount of the claim at paragraph 93 onwards, where he made the same point. He said that the requirement that we should state the amount claimed with a calculation of the loss thereby alleged to have been suffered required us to explain, again, the diminution of value point. And we accept, of course, that the wording in the brackets detailing the calculation of the loss thereby alleged to have been suffered does add something. It does mean something. There needs to be some information about the loss beyond just a statement of it, a bare statement of it in the notice. But the reference, we say, to a calculation of the loss is clearly aimed at something numerical. In other words, it's suggesting not you can't just give a number. You've got to explain how your number is made up. And that is information that we gave in the notice. We explained how, I think the total figure was about 8 million, and we set out in calculated form how that number had been calculated. And again, the defendant may say it's a wrong calculation, or it's not the right way of calculating the loss, but it is nonetheless a statement detailing the calculation of the loss alleged to have been suffered, and to that extent it is compliant with the notice.
Is there something in the words in brackets, detailing the buyer's calculation of the loss thereby alleged to have been suffered? Is something in that?
If your Lordship is asking me whether it imports some further requirement to state causation, I would suggest that it does not. It is simply saying that the amount claimed obviously must be the amount that you say has been lost as a result of the breach. It's identifying what amount has to be stated. It is not, and in particular, if I can put it this way, in particular, it does not go on to say, and stating, for example, why or what basis the loss is alleged to have been suffered by the breach. It is a provision which is aimed at stating the amount and stating how the amount has been calculated, and both of those matters were in the notice. Again, the judge rejected that point at paragraph 95. But with respect to him, it's not really clear why he rejected it. What he says is, if you turn over to page 133, 4 lines down from the top of the page, he refers to Mr. Sybry's observation in ROK that the words in reasonable detail were presumably intended to add something to a requirement to specify the nature of the claim and the amount claimed. It suggests a need to go beyond simply stating a numerical estimate in terms of a bare number. Well, we wouldn't disagree with that, but we didn't simply state a bare number. We stated a number which was made up from a calculation of components. And then I should also, essentially, the reason the judge objected to the notice on the question of amount ultimately is the same reason he rejected it on nature of claim. In other words, he said both the requirement for a nature of a claim and the requirement to state the amount claimed necessarily required the claimant to say that the claim was advanced on a diminution of share value basis. And again, we say that that's outside what can reasonably be understood by nature of claim. There's also ground 3, which concerns the commercial purpose of all of this. As I said by reference to Dodeka at the outset, the commercial purpose is central, and where there is a suggest, doubt about how far a notice needs to go to give reasonable detail, the factors that the Court of Appeal identified in the DICA should be seen as the guide to that. And the problem, I suggest, with the judgment in that respect is that whilst the judge identified that test correctly, he incorrectly applied it. And he deals with commercial purposes between paragraphs 98 to 100. And there are 3 points that he makes. First, at paragraph 98, he says that the additional information, which must mean information that this was a claim brought on a diminution of value basis, he says the information would certainly have been required to understand how the claim was formulated, in terms of how it was said the loss was caused by the breaches alleged, and therefore in order to assess the merits of the claim, as well as to assess the likely quantum of the claim. But again, we rhetorically say, well, why? I mean, we set out in the notice what clauses had been breached and what the facts were that gave rise to the breach, and we given a figure for the loss that we were claiming and what the components of that loss were. Now, that may or may not be a good claim, but I would suggest that no commercial party, accompanied by a commercial lawyer, would have any real difficulty in advising or forming a view on the merits of the claim as set out in the notice, drawing, no doubt, on knowledge of how claims can properly be made in contract. All of the information required to assess the merits of the claim and the quantum were in the notice. To have added to the notice and the legal basis for this claim is that it reflects the difference in the value of the shares, would not, in my submission, have added anything commercially or anything material. So the idea that that information was necessary because otherwise the recipient couldn't understand the claim, couldn't advise on it, couldn't assess the quality is, in my submission, unrealistic. And then at paragraph 99, he has a second reason, which is, he says the other reason it would have been relevant is because if it was a claim for diminution in the value of the shares, that might give rise to issues of valuation, which might become the subject of expert evidence on share valuation in due course. Well, this, again, in my submission, is a slightly curious and unrealistic objection to the notice. As we have formulated the claim, it does not depend on share valuation evidence, or market share valuation evidence, because we have formulated the claim as by reference to what I've loosely called the cost of cure, in other words, the cost of getting the alternative options. Defendants may wish to say in their defence that we've measured the rostrum the long way, and the parties should be looking at market prices and share valuation and so on. But again, those are matters for consideration in the proceedings themselves. It's hard to see how that would have furthered the commercial purposes of the notice. The defendants are perfectly well able to make a judgment on the facts in the notice as to whether they do or don't wish to seek expert evidence on share valuation. And having read the notice, they will be in a perfectly good position to decide that. And to that extent, again, the notice performs its commercial function. And then the final point he makes on this is in relation to paragraph 100, where he says it would be relevant to know whether it was an actual or contingent liability on the part of Scottish Power. Well, again, I mean, I've shown you the passage at the beginning of the notice. It is, and I suggest it would be obvious to a reasonable recipient, a notice put forward on the basis that the claimant is claiming a loss that it has actually suffered. It's actually suffered because the breach has already occurred. And again, the defendant may want to argue that there isn't any such loss, or it's too uncertain, or it hasn't arisen yet. But those are all questions for defence. The notice itself is sufficient to notify the defendant, again, what it's up against in terms of the claim. And as I say, I think one can test all of these points on all of the grounds by asking what a minimally valid notice would have looked like on the defendant's case or on the judge's approach. And in my submission, on the judge's approach, all that could really be said to be missing was the text that we now see in paragraph 23C of the amended particulars, i.e. the reference to diminution in value being calculated by reference to the cost of cure. And seen in that way, in my submission, that would simply made no material difference to the ability of the recipient of the notice to take any of the steps identified into detail. And so, just to summarise our position, if again one were to go back to the reasonable commercial bystander and ask him the question, or her the question, what's the nature of the claim, what's the amount of the claim, how's it being calculated, the answer would be, it's a claim by Drax for breach of certain provisions in the SPA, it's a claim arising out of the failure to transfer the option, it's a claim for damages for £8.1 million for the cost of obtaining an alternative cabling route, and it's calculated by adding up the various numbers set out. And that, in my submission, is minimally what needed to go in the notice. And that information was in the notice, and the judge, in my respectful submission, was wrong to suggest the notification requirements went further than that. Well, Lords, unless there's anything else I can help you with on it.
No, thank you very much, Mr. Quest. Mr. Hussain.
Thank you, Madam. In terms of timing, I'm hoping to be significantly shorter in responding to this appeal than in presenting my appeal, so I'm hoping to divide the time a little bit balanced towards my own appeal.
Well, you'll leave time for Mr. Quest to respond to your appeal, of course.
I will, of course.
We can probably sit till about 4:30 with a bit
grateful.
of luck. But I don't think we can do much more than that, but that should make up a bit of the time.
I'm grateful. My Lord, so on the warranty appeal, we do say that the judgment provides a comprehensive analysis why no diminution in value claim was notified, and why it was necessary in setting out the nature, the amount, the basis of calculation to identify the basis of this claim. Just if I can start, most of what I'm going to say is going to be structured by reference to the judgment, showing the judge's reasons and elaborating a little bit on why they were good reasons. Just identifying first what are, in overview, our answers to the questions that are raised by Drax are. Would a reasonable reader of the notice of claim have understood that a claim was being made for diminution in the value of the shares of the company? We say the judge was obviously right to answer no. And in any case, we have made the point that this is not the subject of any permission to appeal. There was no challenge to the judge's findings about what a reasonable reader would have understood the notice to mean.
But doesn't that beg the question? To ask whether the reasonable reader would have identified a claim for diminution of share value begs the question as to whether you need to say.
That is why I was going to go on to say, really the question is, was it necessary as part of the notice to set out the basis on which the loss was being claimed and calculated? And so the first ground is that required as part of the nature of the claim? And we say the judge was right to say yes. And again, this is just summarising. It extends to identifying what loss is claimed and the basis upon which it is claimed. And whilst authority is not, these are all cases that have to be determined on their particular words and in their particular context. You do find, for example, His Honour Judge Waxman, as he then was in High Water, commenting where a claim had been put in as loss of profits in the notice, and then as a diminution in share value for a larger sum in the particulars of claim, he says these are different types of claim. And we say that that is nothing more than what comes from looking at the nature. Then ground 2, which to some extent one is looking at the same issues that arise in relation to nature. Is it necessary to identify how the loss is calculated in order to set out the reasonable detail of the amount of the claim and the calculation of the loss? Again, we say judge right to say yes. Providing the amount of the claim and its calculation does not just mean providing a figure that has a breakdown. It must be the amount of the loss that is claimed by way of damages and a calculation that explains how that loss has been arrived at. And in that regard, although Milano Friend seeks to characterize diminution in share value as being, as it were, a merely jurisprudential question, it is in fact the framework for how the loss is said to have arisen, and it therefore provides the framework, or you could even say equation, for how the loss is calculated. So the question of how the loss is alleged to have been suffered is not an abstract question, but is necessarily a part of the calculation and the statement of the amount. And then ground 3, does the commercial purpose of the notice provision require the basis upon which damages is claimed stated, or favour that construction? Again, it was common ground, the dicta in Dodica, about broadly the commercial purposes of these notice provisions. Understand the basis of the amount of the claim, investigate matters relating to the amount being claimed, make an assessment of the merits, obtain evidence, and so on. And knowing whether a diminution in value claim, or alternatively a claim for future contingent losses of the company was being made, was of obvious importance. Well, perhaps I can pick that point up first, because that was where Milano Friend ended, just looking at commercial purpose. And there is some sense in doing that, because whether or not the information is going to be useful for the purposes of parties in this position, having regard to the contractual notice provisions and the arrangements, is obviously going to inform the court's view and did inform the judge's view about what the extent of nature, amount, calculation of loss was in this particular provision. And if we look at what the judge said about this, paragraph 97, page 133. So from 97 to 100, the judge considered commercial purpose. And he considered that there were 3 points, so just identifying them. Paragraph 98, it was the assessment of quantum. Paragraph 99 was the valuation issues that would have to be considered in a diminution in value claim. And paragraph 100 was the different notification requirements that would apply, depending on whether, as said, this was a contingent liability based on the retained liabilities of Drax, or a loss already incurred. Now, can I briefly expand on each of those? Because in our submission, these were quite powerful reasons in this case why a party in the position of Scottish Power would want to know the basis upon which the loss was claimed. And first of all, as my Lord Justice Males has pointed out, and for your reference, this is Core tab 16, page 101, there could be no warranty claim unless the aggregated warranty claims exceeded £7.02 million. The amount that is stated in the notice of claim is, depending on the different estimates that are given, either just above or just below. So there were, as you'll recall, there were 2 future bases on which loss might be suffered. One was renegotiating the option, and the other was compulsory purchase. The figures that were given come to 8.138 million on the renegotiation basis, or thereabouts. There were some figures that hadn't yet been given a figure to, but the figures that were given, 8.138 million. And the CPO basis was around 6.685 million. Now, it's not difficult to see that Scottish Power would have wished to look very clearly, or very closely, sorry, at the factors that ought to be taken into account in formulating a diminution in value claim, in order to see whether this really was a claim that would exceed or that did exceed the financial hurdle. So it's a critical point, it's a binary point as to whether or not there is liability. And what my learned friend says is, well, that's why you have to state the amount. So you just state the amount. But that is by no means the end of it, because the point in Dodica is that the recipient of the notice needs to be able to understand for itself what the merit is of the claim that is being made. And in this case, it's really important, if what is being said is a diminution in share value claim, then there are all sorts of considerations that you take into account to see whether or not this is a claim that really exceeds this financial hurdle. So we say the judge was quite right at paragraph 98 to identify the financial hurdle as a significant matter.
Actually, Scottish Power could never be confident at this stage, could they? Even if they could see that this was a claim for, say, £6 million, because there are some claims which have a much longer time limit, e.g. tax claims, I think, and Scottish Power couldn't therefore know whether there were tax claims which were going to come down the line and hit it later.
My Lord, I would accept that there will be a possibility that some other claim that is capable of being aggregated might arise, but that doesn't take away from the very significant moment of being able to reach a view about whether or not, as all the claims that have been either made or threatened, that those claims do not exceed the 7 million threshold. And there is an obligation under paragraph 5.1 of Schedule 4 to notify of any matter that may give rise to a claim. So it's significant that there hadn't been notifications of that kind to suggest that although a claim hadn't been made, one further claim that might be aggregated would be coming down the track. But I accept your Lordship's point in principle. My Lord, I was going to go on to the second point that the judge thought was important, which was the valuation issues. And again, it's really important that one knows that the basis of the claim is being put on a diminution in value. And it's not an answer to it for my learned friend to say, well, we were saying cost of cure. First of all, the difference in value would not assume that all the future costs of cure would be incurred at the valuation date. This is just the time value of money. The biggest part of the figures that were estimated as possible future costs were the 5.05 million additional construction costs that might have to be incurred. So plainly, there is going to be significant discounting for the time value of money in any sensible calculation as to what the difference might be between shares as warranted and the true value of shares at the time of calculation. But, and again, you can only make those sorts of calculations in order to assess for yourself what the merit is of this claim, if you know that you are on the end of a diminution in share value claim. The second point, which would be even more significant, is that on a diminution in value claim, the market value that a reasonable person would have paid for the company when the defect was discovered would necessarily take into account the likelihood that any CCGT would be built, and thus whether any easement or option to acquire an easement would be required. And at the time, it was not known whether a CCGT would ever be built. That depends on whether or not successful bids are made for future power generation in the electricity market. It is not the case today that there are any, that it's known whether any CCGT will be built. And nobody knows whether that's going to be the case. And if no CCGT is being built, then the issue of whether or not this easement or a further option would be required is not going to arise. Now, if one poses the usual question on diminution in share value, what effect did the lack of a deed of covenant in favour of Uniper have on the market value of the shares as at the date of, let's say, the SPA, for the sake of argument? That valuation question, which would be a complex valuation question, is going to depend, amongst other things, on what the likelihood is that the alleged deficiency is ever going to make a difference, because are you ever going to need to acquire an easement over the land in order to make the connection to the electricity transmission network? And this was one of the points that we made as to the way in which the claim is formulated. The draft amended particulars of claim does not accept or acknowledge any need for discounting. So there appears to be a difference between the parties as to how one should approach it. But my point is not that they are accepting discounting. It is that the commercial purpose of being told what the basis is for the claim is precisely to enable the recipient to undertake these kinds of investigations that are going to enable it to assess what the merit is, what the true merit is of the claim. And of course, on the basis of the claim that was notified, namely some future retained liability in respect of losses that might arise in the future, there is no discounting. Either the losses are incurred and passed through, or they're not. But there's no discounting. The discounting only arises because you have if what you're being notified with is a diminution in value claim. And the third point, again, which we say was right, is the paragraph 100 of the judgment, where what the judge observed, rightly, is that in Schedule 4 of the SPA, there are different time limits given for issuing claims depending on the nature of the claim. And that is paragraph 8 of Schedule 4. It might just be worth having a quick look at that if you have it readily available. Forgive me, it's page, you can see it at page 105, core 16. But what paragraph 8 provides forgive me, it's under the heading contingent liabilities, and it says the seller shall not be liable for any relevant claim which arises by reason of a liability which at the time when written notice of the relevant claim is given to the seller is contingent only or is otherwise not capable of being quantified, and the seller shan't be liable to make a payment so on, unless and until the liability becomes an actual liability or becomes capable of being quantified. But and then the remainder of it sets out that the buyer will still be obliged to notify the relevant claim, and the warranty claims are relevant claims within the applicable time limit in paragraph 2 of Schedule 4, but the usual 6-month period that applies for the issuing of the claim after the notification will not apply, and the 6-month period will not in fact commence until the day the buyer actually suffers the loss or incurs the liability. And so what the judge rightly observed is that it's really important for the recipient of the notice to understand whether what is being notified is a loss that has already arisen, which is what a diminution in value, in share value claim would inevitably be, or whether what is being set out is a contingent loss, where losses that are likely heads of loss that may arise in the future are being notified, because in the former case, the claim is going to have to be issued within 6 months of the notice. In the latter case, the claim will only have to be issued within 6 months.
So that
after
may
the
be
loss.
very commercially useful, but Clause 2 doesn't say that, does it?
Forgive me, Mark.
I mean, Clause 2 doesn't say you've got to say if it's a contingent or actual loss, and this notice says both.
Well, my lord, in a way, I've sort of started at the end, but I accept that it doesn't say you have to identify whether it's a contingent loss or not. What I am really drawing attention to is one of the reasons why it matters, and of course commercial purpose is relevant when you
There's
come.
lots of ways you can say why it might matter, which I completely understand. You know, I mean, to know whether you've got a claim for £8 million might affect your accounts, apart
Yes.
from anything else. But all I'm suggesting is that the fact that in Clause 8 there's a rather complicated provision about contingent claims doesn't really tell you what the words of 2 mean.
No, my lord, what it doesn't do, it doesn't add words into what to, and I'm, of course I'm coming back to the
Yes.
words of paragraph 2.
Sorry.
Really, the limit of my submission is that what the cases do agree on is that it's relevant when you're looking at each clause in its context to consider the commercial purpose, the commercial point of providing information. And therefore, you could have clauses where one says one reaches different views about what the language might entail, depending on whether what commercial purpose is served by it. So when one then comes, as I now will do, and look at what views the judge had about the wording of paragraph 2, these points about commercial purpose, which found favour with the judge, are in my submission good points, because what cannot be said by Drax is that we provided them with so much information and it wouldn't have made significant difference to them if we had said, actually, we want to make a claim that's diminution in share value, because it would. My lord, that was really what I wanted to say about the commercial purpose. If one then looks at this point about does the notice of claim notify a diminution in value claim, we accept, of course, the notice of claim was very clear in saying that there was a claim that was being made. It was very clear in saying what clauses had been breached. But what is important is what it was saying about loss. And if one looks at the notice of claim, which is at page 241 of the supplemental, what is very significant about the notice of claim are really the points that your lordships were raising with Milan and Friend. Because one can go and look at the paragraphs from paragraph 35 onwards that set out what is actually being claimed here. And paragraph 37 was rightly regarded as significant by the judge, because what is being said there Drax remains liable for any and all losses suffered by DGL in relation to the reorganisation, is that the events set out in 25 and 26 about the disposal of the company, that in some way, as a result of those events, Drax remains liable for the losses that may be suffered by the company. And it's significant that when one then comes to see the loss being identified, that loss is described as, in the circumstances, the loss suffered is yet to crystallise. And if one looks at paragraph 40 of the notice, it is peppered with references to the future. So you have yet to crystallise, likelihoods of loss, potential loss, likely to be suffered, and another yet to crystallise. And it's not just that what is being said here is about the future. What is being identified here are losses to the company, and also what is being identified here are losses that may arise in a number of different ways. Whereas, of course, if you were talking about a diminution in share value, that would just be one figure. There wouldn't be loss arising in a number of alternative ways. There would be one figure which would represent the number of what the loss had been that had occurred. And these are, the way in which it's put is of substantive significance, because a diminution in share value is not a loss of the company. It's Drax's loss. A diminution in share value is a loss that's already been incurred, not one that may be incurred in the future. And it's a single loss, not a loss that may vary depending on the outcome of future steps. And so if one looks, for example, at the way the losses are expressed, looking at paragraph 42, for example, one asks the question, well, who is going to be incurring these various fees? It's the company. The company is the person that's going to be incurring the option fee, the easement fee, the extension payment, and of course, doing the actual construction. So what is that being identified here are liabilities that may be incurred by the company that Drax remains liable for in some way. Again, if you look at 43, what we're talking about is increased cost due to more onerous contamination obligations. The only exception that I would make is under legal costs and land agent fees. Legal costs has estimated as £100,000 prior to the VPI SPA. So there, that is talking about something in the past exceptionally. Everything else seems to be talking about the future, apart from these two items. And so it's possible that some of these legal costs, estimated 100,000, were incurred by Drax rather than the company. But everything else is going to be incurred by the company, or potentially by the new owner of the company, because Drax has sold it. And then, if one looks at paragraph 44, it's the similar point. On the alternative basis of a compulsory purchase order, we are talking about costs that are going to be incurred by the company. These are not losses to Drax. And I've already said that leaving aside the points that are made about legal costs and land agent fees, which contemplate some past cost, everything else is talking about future costs. And of course, the mere fact that what is being set out here are two alternatives that give rise to two alternative losses, namely the CPO or the renegotiation, tells you that, again, that what is being talked about are losses that, when they are suffered, will be claimed in some way, because there are alternative ways in which they might be incurred. And all of this, in a way, one can test this a little bit by asking, by looking at the particulars of claim and the amended particulars of claim in order to see how Drax understood its claim arose originally versus how it understood, how it now wants to make the claim. And this is well summarised in paragraphs 42 to 48 of the judgment. But if one looks at the draft amended particulars of claim supplement tab 8 at page 272, and one goes to the relevant loss parts, which is starting at page 282, it's quite striking how Drax sought to plead this claim originally.
I mean, it's fairly obvious, isn't it, that they turned on a sixpence and wanted to make a claim for crystallised losses,
Yep.
that losses which were going to crystallise in the future, and then they abandoned that and claimed a loss in share value. But the question is not whether they did that, which everybody accepts they did, but whether, under the terms of Clause 2, they gave you enough information about the claim and were then entitled to change their minds later.
Yes, indeed. The reason why I spent a little bit of time on it is because it is something that throughout, for example, Drax's skeleton argument, when they make their arguments about ground 1 and ground 2, they pepper that argument by reference to, by saying, well, you ought to have, a reasonable reader of the notice of claim would have appreciated that this was a claim that was being advanced on the usual basis, is how they describe it. In other words, diminution in value. And I can give your lordships the references if you want them, but it crops up time and again in their skeleton argument.
No, we've seen that.
And so what they're seeking to do is to actually benefit from some conclusion that a reasonable reader would have understood that the usual basis or diminution in share value was the basis of claim in the notice of claim, in order to support their suggestion that enough was said about the nature of the loss, the amount, and its calculation. And we say that that is simply not available to them, not just because it's not part of the permission to appeal, but because it is so clear from what is said in the notice of claim. It is not just that diminution in value is a missing element that is not stated in the notice of claim. It is in fact that they are putting the case quite deliberately, as a reasonable reader of the notice would assume, in a completely different way, whereby it is based on the retained liability for future contingent liabilities, losses of the company, presumably pursuant to some indemnity in the sale of the company.
Just to be clear, that your submission is that the reader of this letter, even though it never says the word indemnity in that context, would think that that's what this claim must be.
I would put it slightly more broadly than that. I would say my submission is that the reasonable reader of this letter would understand that some arrangements had been entered into in the context of the sale of the company to VPI, pursuant to which Drax retained the liability for losses that might be incurred by the company in the future. And that is what the judge found. Now, the most obvious way that would be is some form of indemnity in that contract of sale, but I don't want to be over specific.
Thank you.
But that was the only way in which losses were being alleged in the notice to have been suffered. And a reasonable recipient of the notice was entitled to proceed on the basis that that was a deliberate choice. But as your lordship observes, what one has to do is go back and say, well, has the wording in context of the paragraph 2 been complied with? That's always going to be the question.
Yeah, and there may be two questions. One, whether what was put forward in good faith, but it's never been suggested here that the notice of claim is not in good faith. And two, whether they are entitled to change their mind later when they bring a claim, provided they have told you what their claim is within the terms of Clause 2 when they did it. And you're not saying, it seems to me, that they're not entitled to change their mind completely, are you?
Well, if it's right that the claim that they had notified in the notice of claim was sufficiently notified that they could now make a diminution in share value claim, then fine, they can do that. My point is that essentially, and this was the judge's reasoning at paragraphs 88 to 89, is that the nature of a claim includes how the loss is alleged to have been suffered. Now, the nature of a claim it doesn't have to be detailed in order to identify
I
the
want
nature.
to be technical about it, but a claiming contract, Mr. Hussain, damage is not an essential element of that claim, is it?
My lord, there is certainly no authority on question of nature that suggests that nature of a claim is limited.
But I asked you about essential elements.
Well, if one is talking about what is
It's a
essential,
matter of law.
I of course agree with your lordship, but where one is advancing a claim for breach of warranty.
But I mean, again, I don't want to be over technical, but this is actually quite important. If it were a claim in tort and you could not show damage, you would not have been able to show the nature of the claim, because without damage there is no tort. But in contract, you don't need to show damage. You're entitled to damages anyway. So here what you have to show is there was a breach of contract, because that's the claim, and that the amount of the loss. Now, why is that not enough? The amount of the loss claimed. It says the nature of the claim, and in reasonable detail, the amount claimed.
Well, my lord, perhaps what I can do is make my submissions in relation to all of the relevant words, because I'll be repeating myself when I come to talk about the amount of the loss and the calculation of the loss. But the language is quite important. So the buyer has noted that what one has to state in reasonable detail is the nature of the claim and the amount claimed, detailing the buyer's calculation of the loss thereby alleged to have been suffered. So it is not just a question of stating the nature or the amount. The bracketed words makes very clear what more you have to identify. Now, as the judge held, and in my submission, as a matter of ordinary language, when you look at what the nature of the claim is, that ought to include what your loss is and how you suffered it. That it doesn't have to include a huge amount of detail, but it has to include that. But what is really important is not just that you have to identify the amount, but that you have to detail the calculation of the loss thereby alleged to have been suffered. Now, that is, in the context of a breach of warranty claim, the calculation of the loss that you are alleging you have suffered as a result of the breach of warranty. So causative elements are essential to that.
Is that from the word thereby? You're saying that the causative element is essential because of the word thereby? Because I'm bound to say at the moment, as I read thereby, it really refers to by the person giving you the notice, or by the notice. That's what thereby means.
I have to confess, I read it differently,
Okay.
but I would be making the same point even if the word thereby didn't arise, because what you're talking about is loss caused by the claim. That must be right in any situation.
Mm-hmm.
And so there has to be reasonable detail of the calculation of the loss that has been caused by the breach of warranty. Now, where that is the case, and just taking all of those factors together, so not splitting it out into nature or amount, but reviewing all of that language, we say the judge was absolutely right to say it is part of that to explain what is the basis upon which you have claimed your loss. Now, that doesn't mean necessarily that you have to say, I am claiming on what lawyers refer to as the diminution in share value basis. But it would require saying, when we acquired the company, it was worth more as warranted than its true worth. And the difference we calculate as this amount. Now, that would be an informative, sufficient basis for the recipient to understand that a diminution in share value has been claimed, along with the explanations that are already given of how figures are arrived.
I mean, you've used the word basis a number of times, but that's rather conspicuously not in the clause.
Well, my lord, I would say that basis comes from the causative connection between the loss and the breach that is inherent in the giving of information about the loss. So I anticipate that the point your lordship has in mind is the argument that Drax make that, well, we've provided a calculation and therefore that must be sufficient. It doesn't have, once there is a breakdown, as they put it, that is all you need. In my respectful submission and the judge's view, that must be incorrect, because this is a calculation of the loss caused by the breach of warranty, and it must be a part of that calculation that you calculate it appropriately according to how you say that loss calculation operates. And in my submission, this is a stark case, my lords, because, again, I repeat the point, this is not a case where there was an absence of information about how this claim was being made. There was a completely different basis from diminution in value that was set out in the notice of claim. And what that means is that you cannot say that you have provided a calculation on the usual basis or the diminution in share value basis, when what you have said is actually we owe a liability to the new owners potentially, and here are some ways in which the company may incur losses in the future. That is simply.
Then you're really saying that what they're telling you is false. That's never been your case.
No, my lord. I'm not saying that there's any. I'm not saying, for example, to your earlier point, that there's a good faith point.
Because you can't. But I mean, the point is, just reading the words detailing the buyer's calculation of the loss, thereby alleged to have been suffered. The normal words mean detailing the buyers. That's their own calculation of the loss they have suffered as a result of the claim they're making, the result of the breach they're claiming for, to have been suffered. And that's what they say they've suffered. Why does it have to go into the full detail of the way it's claimed? And indeed, I mean, even if it's completely wrong that you can claim like that, why does that matter?
It matters, my lord, because
unless it's false.
Well, that I'm not suggesting that. What I'm suggesting is that the requirement of nature amount calculation, that is not something that can be simply abstracted from the nature of the claim that is being made. The way, to give the example of diminution in value, the equation, the way in which one calculates diminution in share value is the difference between the share value as warranted and the true value of the shares. So if somebody is going to perform a calculation, that is the broad parameters of the calculation that they have to undertake. Now,
I
there
think
is,
we're going to have to continue this at 2 o'clock.
forgive me, my lord,
But I think we do very much get the point. 2 o'clock.
excuse me.